Good morning, everyone. Welcome to another segment of ICAN Online Tutors class. Today we'll be looking at business law, and I am your business law lecturer. My name is Afiz Adebimpe. Today we'll be looking at sources of Nigerian law and what are our learning objectives. At the end of this section, as a student, you should be able to define the sources of Nigerian law, explain the types of sources of Nigerian law, and also evaluate the existence of customary law. One interesting thing about sources of Nigerian law is that this topic is very, very interesting. Not that it's only interesting, but then it's highly examinable. There is no direct definition of law, but then it is important we appreciate the ordinary meaning of law. Every country of the world have what they call system of rules and regulation. And the system of rules and regulation, it's built on under which it regulates the conduct and dealings of the people. So every country of the world is expected to be sovereign in nature, and our citizens are expected to follow the rules, the constitution, whatever that is said to be pronouncement within the state. So that suffices me to say law is a system of rules and guidelines which are enforced through social institutions to govern behavior. A very good example, in Nigeria today, we have the three arms of government or three systems of government, and the part that is responsible for lawmaking is the legislative arm. It is expected that when the legislative arm of government makes law, the executive arm of government enforces it, and the judiciary interprets the law, and also ensure that law are fully complied with. So law are made by governments, specifically by their legislatures. Just like I mentioned, in Nigeria, we have the legislative arm of government who is saddled with the responsibility of making law. Now, law can either be written or unwritten. Yes. For instance, we have some custom and traditions that we follow. We call them convention. Most of these conventions are not written anywhere. They are largely unwritten, but then it regulates our conduct. It regulates our human behavior. It regulates our interaction. That's just what law is all about. So when we have it written in a single document or in a separate document that we can collate together to be one, is said to be written. Whether written or unwritten, what is important is that law shape politics, it shape economic, it shape the society, it shape the citizens within the society. So everybody within the system is expected to follow the law of the state. A very good example is the Nigerian Constitution. The section 1, subsection 1 talks about supremacy of the Nigerian Constitution. And the Nigerian Constitution has a bounding force and authority on every citizen of Nigeria, and everybody must follow by the provisions of that constitution. So what are the sources of Nigerian law? By sources of Nigerian law, we mean where Nigerian law that we use today derive its validity. Here we're talking about this fountain of authority where Nigerian law derive its validity. For the purpose of this class, we'll be looking at 5 major sources of Nigerian law. The first one is the received English law, the Nigerian legislation, customary law, case law or judicial precedents, and lastly, international law. There's need for me to mention again that for exam purpose, received English law, Nigerian legislation, and customary law. We've seen situations where examiner coin questions from this area and give it to students. So it is very important you pay attention to this part of the lecture, and as well, try as much as possible to study after this class and you can bring forward to me your questions. So the sources of Nigerian law, we are looking at it from 5 angles. The received English law, Nigerian legislation, customary law, case law, which is also known as judicial proceedings, and lastly, international law. The first three seem to be more of primary sources of Nigerian law, and also they are examinable. Now, the received English law is divided into 3. The first one is the common law, the second one is the doctrine of equity, and lastly, statutes of general application. Going by history, the British colonized Nigeria. Prior to the absolute colonization, we used to have what we call indirect rule, right? So during this period, the Britain had to rule Nigeria through our traditional rulers. Thereafter, they come in and take proper control of Nigeria. And that is where the word colonialism starts from. At that time, they divided Nigeria into 2 separate entities, Lagos Colony and the Protectorate. So we have the Southern Protectorate, we have the Northern Protectorate, and we have the colony. So we have colony and we have Protectorate. So for colony are seen as direct citizens of the British Crown, right? They are direct citizens, and they are treated just like the same thing like the citizen of England. But the Protectorate are citizens also, but they are subject to the government regulation, that's in England. So the major difference is that one is seen as first class and the other one is seen as what? British subject. Now, within this period, the British identify or introduce 3 different types of rules into Nigerian system. The first one being the common law. When we say common law, just like I mentioned, that the people of the colony are under the what? The control of the British Crown. So they are seen like the first-class citizen, and they are directly governed by the Queen of England. Common law at that point in time is basic to the people of England. Common law is like their basic law, which is directly attributable to the people of England. And it is important to know that it is developed by the old common law court. One principle or one demerit of common law is that common law is very rigid. Yeah, common law is very rigid. There's always a popular saying that where there is no right, there is no remedy. So what that simply means is that you must have an appropriate position for you to bring up your case. So common law is very rigid. It does not bring into aspiration of the people. So because of the rigidity of common law, there is need for us to bring in a law that would take into cognizance the view of the people, the yearnings of the people, and the interest of the people. Then another one comes in, which we know as doctrine of equity. So for doctrine of equity, it does not come to abrogate common law, but to supplement it. By supplementing, what that means is that doctrine of equity also comes on its own, but the objective of doctrine of equity is to support provisions of common law. On its own, it stands, but where common law did not take into consideration aspiration of the people, doctrine of equity comes to replace all of those. So it comes in 2 ways. We have the general equity and we have the technical equity. For general equity, the objective is to say, whatever that you want to promote, it must be in line with natural justice, fairness, morality, good conscience. Now, technical equity implies that whatever we are doing, it must follow the basic law of what? England, and it is developed by the Court of Chancery. Now, doctrine of equity has its own ingredients, has its own maxims. Remember something, doctrine of equity comes to give justice to whom justice is ought to be given. Common law, one of the deficiencies of common law is very rigid. It does not give into consideration what the people demand. Most of the time, it does not pass through the normal route, and it's very harsh on the part of the citizen. So doctrine of equity is like giving justice to whom justice is due to. Now, for you to enjoy doctrine of equity, it comes with certain maxims. And those maxims is what we call maxims of equity. It helps us to bring into consideration equitable establishment. The first one is of the maximum of equity is equity will not suffer a wrong without remedy. So equity will not suffer a wrong without remedy. And that is the premise with which the Court of Chancery established doctrine of equity. We have a problem on ground, and we want to ensure that the problem of the people is looked into, is looked after, and their interest is taken into consideration. He who comes to equity must come with clean hand. He who seeks equity must do equity. Very important. Where the equities are equal, the first in time prevails. So what we are saying is that where we have two equity, the first in time prevails. And equity, like I mentioned earlier, follows the law. Even that's supposed to be the number one, because no equity will come to existence without position of the law of the land. Delay defeats equity. So if you want justice, you must be fast with it. Equity aids the vigilant and not the indolent. These maxims of equity are so important that you need to understand them to be able to sue under the doctrine of equity. You need to understand them to be able to enjoy the dividend under the doctrine of equity. Each and every maxim of equity have its implications. The third one, under the received English law, is statute of general application. Statutes of general application are law that is derived from various adaptation of law. It also comes alongside with the other two laws, that's equity and common law. So we have it applied in the area of business. We have it applied in the area of trade. Now, going by the next one is Nigerian legislation. Nigerian legislation, as it implies, they are locally made law. They are laws that are made by the Nigerians. For received English law, they are laws that are made by the British and expect Nigeria to follow it. But for Nigerian legislation, it is the law that is made by Nigerians, by our lawmaking body in Nigeria. The first we'll be looking at is the Act. Act simply means the law that is made by the National Assembly in the democratic system of government. It is also called Act of Parliament. Don't forget I mentioned the legislative arm of government comprises of the Senate and the House of Representatives, right? Their own responsibility is to make law for the state. We call them the National House of Assembly. So at the federal level, in a civilian system of government, the law that is made is what we call acts. In a military system of government, the law that is made at the central or federal level is known as decree. In a civilian government, the law that is enacted at the state level is what we call laws. In a military system of government, of course, the law that is made at the state level, just like normal civilian system of government at the state level, it is called law. In a military system of government, it is called edicts. And bylaw is made at the local government level, both at military system of government and at the civilian system of government. And we have what we call Nigerian Constitution. Just like I mentioned earlier, the Nigerian Constitution is the book that is containing the law of the land. and the citizens of Nigeria are expected to abide by it. And a very good example is the section 1 of the Constitution that talks about the supremacy of the Constitution, that the Nigerian Constitution have binding forces on all persons and authority throughout the Federal Republic of Nigeria. So let me take that again. Nigerian legislation is divided into 6. We have the Act, the law made by the National Assembly in a civilian regime. We have decree, the law made at the central level in a military regime. We have laws, the enactment that are made by the House of Assembly in the what? In the civilian government at the state level. There's what we call edit. Edit is made at the state level in a military regime. And lastly, we have the bylaw. Bylaw are those laws that are made at the local government level, both in the military regime and the democratic government regime. And also the Nigerian Constitution, that is the book that contains the law of the land. Customary law. Customary law, as it implies, Nigeria as a country, at the moment we have 36 states and we have over 250 ethnic groups in Nigeria. And each of these ethnic groups, they have their own fundamental tradition and culture that is peculiar to them. So it is important to know that each team will have their own custom that they follow. That is where customary law derives its existence from. So customary law refers to as the law that is applicable to the indigenous people of Nigeria. It is particular to a community. Each and every community has their own law, and it varies from one community to the other. It varies from one community to the other. We have two types of customary law: the ethnic customary law and the Islamic Sharia law. The ethnic customary law is also known as indigenous law and is applicable to the member of that particular ethnic group or community. For Islamic Sharia law, it is only applicable to the people that belong to that faith. Most of them are Muslims, right? And it's possible you have a state that is dominated by Muslims. There's high likelihood that they use Islamic Sharia law. But in Nigeria today, Section 10 of our Constitution prohibits a state of being dominated for religion. So it is expected that anywhere you find yourself, you can practice your religion, but at least you must go by the law of the land. What are the characteristics of customary law? Customary law are flexible. Yeah. Customary law are flexible. Why? Because they are not written. Most of the customary law are not written, especially the ethnic customary law. Except for Islamic Sharia law that are written. Because it is written, it makes it not flexible, because when something is written, to change it, you have to follow a certain process, which could be hard. Customary law is acceptable, and that's one of the most interesting part of customary law, is acceptability, because the people believe that this law belongs to us, it belongs to our forefather, it belongs to our tradition. More reason why they follow it. Now, before a customary law becomes a law to be recognized in Nigeria, it must pass through what we call validity test, and it must pass through proof of existence. Proof of existence. It must pass through proof of existence. So for validity test, we are talking about three things here. The first one being repugnancy test, test of incompatibility, public policy test. And for proof of existence, we're talking about, it can either be direct oral evidence, documentary oral evidence, and judicial notice. So let me take it one after the other. Repugnancy test, the court has not defined exactly what the term repugnancy test means, but then there's a popular case, Edet and ICAN, that we use in appreciating the repugnancy test. But the summary is this: for us to pass anything as customary law in Nigerian court, it must not be barbaric. It must not be primitive. It must not be against natural justice, good conscience, and morality. It must be perfect, and it must align with equality. It must align with natural justice and good conscience. Incompatibility test. For incompatibility test, our objective is saying for us to allow a customary law to be passed as a customary law in the country, it must be compatible with the law of the land. It must be compatible with any law invoked at that point in time. For instance, now, if we have a law that says this, customary law at that point in time must align with it. For instance, if there is a law that prohibits killing of twins, the customary law in town must go by that. That is when it can be compatible with. Public policy test is explaining the fact that it must, of course, it must align with the total view of the people. For proof of customary law, it can be proved in three ways: direct oral evidence. For direct oral evidence, there must be people such as the priests, the elderly people, the emirs, the obese that witness its existence. These are people that have stories with them, that have facts with them, that can actually pass it on to the next generation. So there must be a direct oral evidence of the existence of this customary law. This is how it is done, this is how it is done, and this is how it is done. Documentary evidence, we must be able to establish that, okay, there is a manuscript, there is a document evidencing that at so point in time, this law exists and it is documented and the people follow it. For the judicial notice, intend to prove a custom by judicial notice, a person is simply asking the court to accept the custom as existing because a higher or coordinate court had in previous proceedings repeatedly accepted the custom as existing. Here we are trying to establish judicial precedent, but in the area of customary point of view. So for us to say, okay, oh, judicial notice, here we're talking about the court of law is aware of the existence of that act, is aware of the existence of that custom, because a court of higher jurisdiction or a court of same jurisdiction at point in time have accepted that this custom exists. On that ground, customary law is said to have been proved to be in existence. Case law. Case law is also refers to as judicial precedents. What is judicial precedents? Judicial precedent is one of the sources of law where past decision of the judges creates law for future judge to follow. So what we are saying in existence is that judicial precedent establish the fact that in coming up with a pronouncement, a decision made by the court can actually form a basis for future judge to follow. And if that is the case, it is said to be what? Judicial precedent. Judicial precedent is divided into three. We have ordinary precedent, we have original precedent, we have persuasive precedent, and we have binding precedent. Ordinary precedent is what is known as original precedent. For original precedent, we are saying that this is a decision for the first time that form the basis for future judges to follow. When we say persuasive precedent, is a decision that is made within the court of coordinate jurisdiction Other court within that level are at liberty, at discretion to follow it. While binding precedent, the objective is that a decision made by the court of higher jurisdiction, a lower court is expected to follow it. It is binding on the lower court to follow. Now, when examining judicial precedent, we take into cognizance 2 points: ratio decidendi and obiter dictum. So not every aspect of past decision constitutes a precedent. Rather, it is the material fact plus the decision therein known as ratio decidendi that constitutes a decision. The remainder of the past decision which does not constitute a precedent and which need not be followed is known as the obiter dictum, that is, a statement by the way. So when we're talking about ratio decidendi, we're talking about material part of a case, the major point in issue, the position conclude on in that decision is the ratio decidendi. So in making that decision, whatever statement that does not constitute a pronouncement is known as obiter dictum, a statement by the way. So I've mentioned this before, type of judicial precedent, original precedent is being made for the first time, that other precedent, binding precedent, the decision is made by the higher court and the court of lower jurisdiction is expected to follow it. We are going to appreciate a case on that. And persuasive precedent. On persuasive precedent, the objective is the decision is made by court within the same jurisdiction. So other court within that same jurisdiction are of liberty to follow it. They are not mandatory to follow it 100%. The last one being international law. Nigeria belongs to a lot of countries, of a lot of international organizations such as UNO, Commonwealth. So it is important that the law established by this world organization, Nigeria is expected to follow them. So one way or the other, they also have their way of, pushing for the law to regulate Nigeria. So because Nigeria belongs to the international organization, they have to comply with their law. So one way or the other, it forms the fountain of authority of Nigerian sources of law. A very good example is the provision of the fundamental human rights as contained in the Chapter 4 of the Nigerian Constitution. So the United Nations Organization have a segment of international justice, of course, justice, ICJ. So what's the objective? One of the objectives is that to ensure that, okay, country of the world, their citizens' rights are guaranteed. They also have their own charter, which Nigeria is expected to follow. So we have some questions for us. Thank you. So the first question here is, the Nigerian law has been tremendously influenced by English law, which constitute the origin of a substantial part of our law. Secondly, Nigeria is a complex society, and this extends to our legal system. We require to discuss the sources of Nigerian law. So, what do they expect us to do here? What they actually expect us to do is to list and explain the sources of Nigerian law. So you start with receive English law. We explain what it means, that the law that is introduced into Nigeria by the Britain, right? And upon colonization, 3 laws were introduced. Common law. The common law is the law that is basic to the people of England. Common law is rigid, and because of the rigidity of common law, they need to introduce a law that will guarantee the interest at the end of the people materialize. And that is why we have what we call doctrine of equity. For doctrine of equity, it comes in two ways, right? The basic equity and the technical equity. But the objective of doctrine of equity is not to abrogate or cancel common law, but to supplement it. Doctrine of equity comes with its own maxims. We have such as, if he who come to equity must come with clean hands. Equity follow the law. Where there are two equity, the first in time prevails. These are maxims of equity that for us to enjoy the benefit of equity, it's very important we understand the maxims. And lastly is statute of general application. Statute of general application are laws that are derived from various adaptation of law. A very good example is Partnership Act of 1893. I beg your pardon, Partnership Act of 1890, Sales of Goods Act of 1893, and so on and so forth. They are laws that are specific to different causes. The second one is the Nigerian legislation, that the law that are locally made in Nigeria. We start with Act. The Act is the law made at the federal level in a civilian state. We have laws. Laws are made at the state level in a civilian state. We have decree. Decree are made at the federal level in a military state or in a military system of government. At the state level, it is called decree. So bylaw is made at local government level, both in the civilian state and in the military system of government. And lastly, we also appreciate constitution. We define constitution as the book that contains the law of the land. And we reference section 1 of the Nigerian Constitution that talks about supremacy of the Nigerian Constitution, saying that the Nigerian Constitution binds every individual in Nigeria, and we're expected to work and act by the provision of that constitution. We also talked about customary law. Customary law here represents the law that is indigenous to the people of Nigeria. Customary law is divided into two: ethnic customary law and Islamic Sharia law. For ethnic customary law, like we mentioned, we have different communities, we have different ethnics in Nigeria, and every ethnic, all ethnic, each and every one of them have their own peculiar customs, their peculiar traditions, their peculiar norms. Thereby, customary law is globally accepted by these people because they accept it as binding on them. The Islamic Sharia law is particular to the people that belong to that faith. The Islamic Sharia law derive their source of authority from three divisions or three angles. The first one being the Holy Quran, the second one being the hadith of the Prophet, and the last one being the consensus of the scholars. But the two are seen to be the paramount, that's the Quran and the hadith. We also talked about judicial precedent. We said the judicial precedent form the basis for future judge, that the decision made now by today's court form the basis for future judges to follow. And we looked at judicial precedent in three ways. The first one being original precedent, followed by binding precedent, and lastly, persuasive precedent. For original precedent is a decision that is being made for the first time. Binding precedent, a decision that is made by the court of higher jurisdiction and is binding on lower court to follow. The persuasive precedent is made by a court within the same jurisdiction. I think we have a question. I think in our next class, I'll show us a question on that, where a particular court came up with a decision and other court within and below that jurisdiction is expected to follow it. So we are going to appreciate which one is original, which one is binding, and which one is persuasive. Law contained in judgment of court is A, case law, B, statute, C, civil law, D, criminal law, E, common law. The answer is case law. Case law is also called judicial precedent. and judicial precedence is also known as case law. Thank you for attending to this class. See you in our next class. Thank you.